Okay, let me just grab the mouse. Okay, so welcome everyone to today's webinar on the Pregnant Workers Fairness Act. There's been a lot of action both at the federal and state level recently relative to pregnancy. This is just one aspect of it. Ariana and myself have put our contact information here. In case you think of a question, after, that's fine. Feel free to email one or both of us, and we'll get back to you. And with that, I'm going to turn it over to my colleague. She's going to start out, and I will finish the presentation.
Great. Thank you, Mike. So good morning, everyone. As Mike said, today we're going to be talking about the Pregnant Workers Fairness Act. This is just our agenda for this morning. We'll talk a little bit about the act, when it was enacted, who it applies to, and then the EEOC published its regulations to the Pregnant Workers Fairness Act back in April. So we wanted to go through those with you this morning and kind of give you just a rundown of what's included, because with any regulations, as we all know, if you're pulling up the regs and you're reading them, they are very word dense, and difficult to understand, even for Mike and I, and we are looking at them on an almost daily basis. So with that, I will jump right into it. Give me one second here. Mike, did you turn control over to me?
I did. Let me do it again.
Okay.
Bear with me. You got it?
Let's see.
No, do you have it?
No, it's not.
All right, give me 1 second.
No problem.
It says you have it.
Okay. Give me 1 second. I just want to make sure. Okay, there we go. Okay, thanks. Sorry about that, everyone. Mike and I do these all the time, and it's been for a few years now, but stuff happens. So, talk a little bit about the purpose of the PWFA. The EEOC has said that the purpose is to ensure that employers provide reasonable accommodations for employees or applicants. So, the PWFA applies not only to your employees, but also to applicants, with known limitations related to pregnancy, childbirth, or related conditions. So what we're going to go through this morning is what all this means. What are reasonable accommodations? What are known limitations? And how does the EEOC define, obviously pregnancy, but also conditions that are related to pregnancy, or childbirth? So you might be thinking this morning, okay, so I've been working with employees and human resources for a while. I know that Title VII in the New York State Human Rights Law prohibit discrimination on the basis of gender. And I know that the ADA, although pregnancy might not be a disability under the ADA and the New York State Human Rights Law, but there are certain protections in place for workers who are pregnant. So what is different about the PWFA? And what's different is that the focus of the PWFA is on accommodations. So what we're looking at is what accommodations may be required to be granted to employees who are pregnant or who have related medical conditions. Just like the ADA, and Mike will talk about this a little bit later, there is an exception if the accommodation will cause an undue hardship. So we'll get into that a little bit later. As I mentioned a few minutes ago, these regulations went into effect on April 15th. The PWFA applies to employers with 15 or more employees, so similar to other federal statutes. If you're under that 15 employee threshold, then I'm not suggesting you ignore the PWFA, but and a lot of this stuff will come into play, and Mike will talk a little bit later about how this comes into play with New York law, particularly with respect to lactation accommodation. But generally speaking, it applies to employers with 15 or more employees. The PWFA is enforced by the EEOC. As I mentioned, the EEOC has published the regulations that we're going to talk through this morning. And what that means is under this particular statute, an employee must exhaust administrative remedies by first filing a charge with the EEOC. So, much like Title VII and other federal statutes, if an employee believes that they've been discriminated against under under the PWFA, that employee must first file a charge of discrimination with the EEOC, and we'll talk about that a little bit later. So, with that kind of background, let's jump right into what the regulations say. So, as I mentioned a few moments ago, an accommodation is necessary for an employee who has a known limitation. The regulations defined a known limitation as a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical condition that the employee has communicated to the employer, whether or not the condition meets the definition of disability under the ADA. So we're going to talk about this in a few minutes. As I mentioned earlier in the presentation, the ADA, of course, we're all familiar with, and we're going to talk a little bit about why the PWFA is different than the ADA. But just to preview it for you, in case you kind of haven't drawn the conclusion yet, the PWFA seems to be a bit broader in terms of what is covered and accommodations that are presumed to be reasonable. So in order for a limitation to be known, that means that the employee or the employee's representative, so you can think partner, spouse, etc., has communicated the limitation to someone with supervisory authority for the employee, HR personnel, or by following the steps in the employer's policy to request an accommodation. So the EEOC is kind of laying out for us what known means under the regulations. And basically, this means that you as the employer have to be notified of the limitation explicitly. The regulations say that the communication may be made orally, in writing, or by other effective means, but the communication does not have to be in writing, be in a specific format, use specific words, or be on a specific form in order for it to be communicated to the employer. So a lot of us on the call, we probably have reasonable accommodation policies. We probably have handbooks that kind of lay out how you can request a reasonable accommodation. That is fine, and that can actually apply to an accommodation requested under the PWFA. But the regulations really make clear and underscore that that is not the only way that a limitation can be communicated to an employer. And in fact, there are no magic words, much like when we discussed the ADA and a request for an accommodation, right? There's no magic words, no specific words can be required. It just needs to be, the limitation needs to be reported to a supervisor, HR, or someone with an equal position. So that's the known piece of it. Let's talk next about the limitation. So under the regulations, the known limitation means a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. So that's a mouthful. Let's break that down. This is, I think, one of the most significant things about the PWFA. The PWFA says that the limitation can be an impediment or problem that is modest, minor, and or episodic, a need or problem related to maintaining the employee's health or the health of the pregnancy, or seeking health care related to the pregnancy, childbirth, or related medical condition. So this is kind of similar to the ADA, but the regulations are basically saying that the limitation can be something that is modest or minor, and we'll talk about that in a couple of minutes. So the regulations define pregnancy and childbirth, fairly straightforward definitions. Current pregnancy, this also includes past pregnancy. So if you've had an employee who unfortunately has miscarried, and there are conditions or the employee needs an accommodation related to the miscarriage, that would fall under the PWFA's umbrella. Potential or intended pregnancy. I wanted to point this out because this means complications or accommodations that are needed for fertility treatments, infertility, contraception use, and then, of course, labor and childbirth. And the regulations say that this covers vaginal and cesarean delivery. The regulations also give us a few examples of related medical conditions. So related is termination of pregnancy, so miscarriage, stillbirth, abortion. You may have seen throughout the news that there have been some challenges to the PWFA on this basis, basically the constitutionality or whether the EEOC has the authority to include termination of pregnancy or abortion in the regulations. I believe if you are, the federal courts have addressed this in Louisiana and Kentucky. I believe if you are in Louisiana or have employees who are in Louisiana, the PWFA has been enjoined, which means it's not to be enforced there. But basically in New York and everywhere else, the PWFA is going strong. So I wanted to point that out, and we'll have to keep a look at the courts and see what happens there. Ectopic pregnancy, preterm labor, pelvic prolapse, gestational diabetes, preeclampsia or high blood pressure. Other related medical conditions include psychological conditions like anxiety, depression, psychosis. Lactation and related conditions, Mike will talk about that a little bit later. Chronic migraines, dehydration, edema of the extremities. So basically, that means swelling, incontinence, balance, changes in hormone levels. And, there are many examples included in the regulations. But what I think is important to point out with this is that it really underscores the purpose and the PWFA's a lack of requirement really that a condition be severe. It can be very minor, it can be episodic. Barclay Damon held a labor and employment conference at Turning Stone a few weeks ago. It was an all-day conference. We gave presentations on a number of topics, one of which was the PWFA and the regulations. And our keynote speaker at the LNE conference was Maureen Kilt. Some of us on the call may be familiar with Maureen. She is the director for the EEOC for the regional director. So she basically handles all of upstate New York. And she's the one who kind of looks at every charge that comes in and determines whether, the threshold requirements are met and whether the charge can proceed to investigation. But I bring it up because what Maureen really underscored during her part of the presentation was that the limitation under the PWFA can really be pretty much anything that is causing the employee to be limited in performing their duties. So I thought it would be helpful to include some of these examples because just from reading them, I think at first blush we don't actually think, oh, swelling, edema of the feet, of the hands, etc. But it can be a related medical condition under the regulations. And while the regulations provide the foregoing examples, the list is not exhaustive, and the regulations say that specifically. So basically what that means is if you have an employee coming to you with a condition that's not on the list that we've provided with you, that doesn't necessarily mean that they are disqualified or that they don't have a related medical condition under the regulations. So there is also a requirement under the PWFA, similar to the ADA, that the employee be qualified. Like I put in our presentation, this is very similar to the ADA. An employee or applicant who, with or without reasonable accommodation, can perform the essential functions of the employment position. But the PWFA makes clear that even if an employee or applicant cannot perform all essential functions of the position, the employee can be qualified if the inability to perform an essential job function is for a temporary period, the essential job function could be performed in the near future, and the inability to perform the essential function can be reasonably accommodated. So we'll give a couple real life examples of this, but basically the PWFA is saying that an employee can be qualified under the PWFA if the inability to perform the job function is for a temporary period and could be performed in the near future. Now, do the regulations address what is temporary? And the answer is yes. The regulations say that temporary means lasting for a limited time, not permanent, and may extend beyond in the near future. If I'm reading the regulations, or I should say when I'm reading the regulations, or if I'm you and I'm listening to the presentation, I was thinking, or I would be thinking, what is the near future? And the EEOC has basically said through the regulations and its own guidance that the near future is determined on a case-by-case basis. But if the employee is pregnant, it is presumed that the near future is generally within 40 weeks, so which is essentially the length of the pregnancy. So we've talked about what's known under the statute, what's a limitation, pregnancy, other related medical conditions, and we've talked about how an employee may be qualified. So I think it makes sense for us to kind of switch and talk a little bit about how the employee could be reasonably accommodated. And this, I think, is getting into one of the main reasons why the PWFA is a little bit different than the ADA and a little bit broader. The regulations say that an employee can be reasonably accommodated by the temporary suspension of the essential functions and the employee performing the remaining functions of their position, or depending on the position, other arrangements, including but not limited to performing the remaining functions of their position, the employee performing the functions of a different job to which the employer temporarily transfers or assigns the employee, or the employee being assigned to light duty or modified duty or participating in the covered entity or the employer's light or modified duty program. So Real life example of this morning, just before I hopped on the webinar, I had a question from a client. They had an employee who is pregnant. She's been out for a number of weeks. And essentially, the reason why she's been out is because the employee is in the healthcare setting. She's essentially a nurse's aide in a residential nursing home facility. And she cannot lift right over 20 pounds. And the client has said, well, that is an essential function of the position. So, what do we do? Do we have to kind of make an accommodation for that inability to lift 20 pounds? Do we assign her to light duty? Can we put her in a different position temporarily until she comes back from her maternity leave? And we talked it out, and the answer was really yes. I mean, if there is another position that's available or a light duty program that's available, the PWFA makes clear that that's something that can be a reasonable accommodation, and that the temporary suspension of the essential job duty, or in this case, the inability to lift in excess of 20 pounds, can be temporarily suspended. So with that employee, I think what we're going to end up doing is giving her a lighter duty position, and I think that that's a sound approach under the PWFA. So, as I mentioned a couple of minutes ago, the essential functions test is outlined in the regulations. The EEOC has said that the essential functions mean the fundamental job duties of the employment position that the employee holds or desires, and it does not include the marginal functions of the position. So, I read this not super helpful, but it seems that it needs to be something more than marginal, right? Probably a focus of the employee's duties. The regulations, though, do say that in determining whether a function is essential, the employer can consider, that the function could be essential because the reason the position exists is to perform that function. So if it's really the principal job duty of the employee, the function can be essential because of the limited number of employees available among whom the performance of that job function can be distributed. In other words, this is the only person at the company who's responsible for this essential function. And without them being able to do it, there's no one else who can take over. And or the function may be highly specialized so that the incumbent in the position is hired for their expertise or ability to perform the particular function. So you have a really niche position with your organization. You hire this person specifically to perform it. There's no backup. I think you have a good case that is an essential function of the position. Now, the EEOC gives some guidance to employers in terms of what they will look at to determine whether a particular function is essential under the PWFA. Evidence of whether that is a sound determination includes, but is not limited to, the employer's judgment. So your own judgment as to which functions are essential, written job descriptions prepared before advertising or interviewing applicants for the job, amount of time that will be spent on the job performing the function during the time the requested accommodation will be in effect, the consequences of not requiring the employee to perform the function. If you have a CBA, the terms of the CBA can be considered, the work experience of other employees in the job, or the current work experience of employees in similar jobs. So this is basically the EEOC saying, if you get to the point where an accommodation has been requested and you're trying to make a determination of whether or not it can be accommodated because you're looking at whether an essential function is really at play and there's anyone else to do the job, these are some kind of guideposts that you can look at. But like under the ADA, and I'm sure most of us on the call have been in this position, there is no clear-cut answer, and it's really a weighing of several factors. So let's move on to reasonable accommodations and what reasonable accommodations the EEOC has provided for us and how they've enlightened us on this topic. And I'm going to start with this, and then I'm going to turn it over to Mike in a couple of moments. But the EEOC has said that modifications or adjustments to a job application process are reasonable accommodations, modifications or adjustments to the work environment as well, modifications or adjustments that enable the employee with a known limitation under the PWFA to enjoy equal benefits and privileges of employment. And as we talked about a few moments ago, temporary suspension of essential functions and or modifications that permit the suspension of essential functions. So that's a lot. Let's talk about how that might play out. the regulations do provide specific examples of reasonable accommodations. Some of these are very straightforward, such as modifications of uniforms or equipment. If you have an employee coming to you and says, "I'm pregnant, I need a larger uniform," I think that's a no-brainer. We give them the larger uniform and we move on. Permitting the use of paid or unpaid leave. So if you have an employee who maybe has come, they're not eligible, they've been with you a short period of time, they're not eligible for your paid leave or PTO program, they're not eligible for statutorily paid leave, or unpaid leave, this is an accommodation you need to look at. As we talked about a few minutes ago, assignment to light or modified work. Telework, obviously that's a big issue and has been for a few years now and remains that to be that way. Job restructuring, like we talked about, even part-time schedule, that's something that EEOC has said could be a reasonable accommodation, or temporary reassignment. And I want to talk a little bit about these predictable assessments. This is what the EEOC has kind of highlighted as instances where an accommodation will almost always be reasonable. And this is taken right from the regulations. And the EEOC says that if an employee needs more frequent breaks for use of the restroom, drinking and or eating as needed, that's most likely going to be a reasonable accommodation. Allowing an employee to carry or keep water near them, again, more likely than not, always going to be a reasonable accommodation. Allowing an employee to take breaks to eat and drink as needed, same thing. And allowing an employee whose work requires standing to sit or sitting to stand as needed. So the EEOC has said that these predictable assessments will, in virtually all cases, be found to be reasonable accommodations that do not impose an undue hardship when requested by a pregnant employee. So, I mean, that's not to say if you're in an industry where you have some OSHA, you have health and safety plans, you have OSHA plans, you have things that prevent employees from eating or drinking on the floor, for example, we can work around that. Let us know if you have questions on that. But virtually in all cases, the EEOC has said that this will be reasonable. And Mike, I apologize. I took one of your slides, so I'm going to turn it over to you.
That's not the end of the earth. So, but thanks, Ari. All right, let's grab this back. Okay, so let's start with lactation accommodations. I would stress here, we have the federal Pump Act and we have New York's version of that, which is much, much broader and is much, much more detailed. The lactation accommodations generally will go beyond the federal requirements. Here in New York, we have to comply with the state requirements, which have been around for years. In 2023, we had a major overhaul and update of those, and in 2024, slight update of those. Generally speaking, I think if you follow those guidelines, you're going to be in perfect shape for lactation accommodations. Other things may come up during the employee making requests, and let's see what those are. Handle them reasonably, and this is not meant to be a rigid process. It's meant to be a very flexible, open-ended process where the employee asks and doesn't have to necessarily fill out a form, and just be flexible. Is my opinion. Under lactation accommodations, this basically, let's be practical during work hours. Does the employee work from home? Is there daycare in the building? What are we going to do relative to accommodations during work hours, where it is practical to be in close proximity to the child? Those are things you're going to have to consider. I'm breastfeeding. I need to go to the daycare that is downstairs to do that. I think it's a no-brainer that you're going to have to grant that accommodation request. When choosing among effective accommodations, you as the employer must choose the accommodation that provides the employee with the limitation equal employment opportunity to attain the same level of performance or enjoy the same level of benefits and privileges as are available to the average employee without a known limitation who is similarly situated. Wow, that's a mouthful. It is. And let's try to simplify it for you. we're going to treat the female employee who has the pregnancy-related condition the same as someone who does not, and basically give them the same benefits and privileges of employment and the same opportunities relative to employment. So it's a fancy way of saying, don't discriminate. And that's sort of how I look at it, nice and simple. A few things that the regulations sort of outline for us are unlawful employment practices. And in a few minutes, we'll talk about, they can how they bring a claim and things along those lines. These are things to avoid at all costs. First, it's unlawful for you as an employer to require an employee to take leave, paid or unpaid, if another reasonable accommodation can be provided that does not cause an undue hardship. So before we make the employee hit their paid leave bank, or we force the employee to take unpaid leave, we have to exhaust all other accommodations, so long as they don't create some type of undue hardship. And just generally speaking, we're going to talk about undue hardship in a second, but undue hardship, it really better be that. You just can't claim, oh, that's a hardship. Yeah, there's a lot of hardships in employment. Undue has a meaning. It is, there's an analysis we're going to have to run through, and it better be something that the feds will accept as undue hardship, because they will look at it very, very closely. Another unlawful employment practice for you as employers is to require that an employee accept an accommodation other than a reasonable accommodation arrived at through the interactive process. What does that mean? You can't force something down their throat if it wasn't arrived at by mutual agreement. So you as the employer say, no, here's this is what we're going to do. This is how we're going to do it. Don't care to even address it with you, employee. That's going to be a violation there. You must address it with the employee. You must engage in the interactive process. And, we'll talk about it a little bit more, but I like employers to document it every step of the way. So let's say you had a meeting with the employee about a reasonable accommodation. What are we going to do after the meeting? We're either going to, maybe we'll do a memo to the file as to what happened. Maybe there's a confirming email back to the employee. We just went through a accommodation process with an employee, and the request for accommodations were 5 pages long, single spaced, from a healthcare provider. And we're like, oh my, yeah, it took us about 20 hours of time over 2 weeks with the employee to even go through all of everything. And, something was arrived at, but that's exactly what we did. We did a memo to the file about each meeting. We did confirmatory emails at the end. When we had an agreement on the accommodations, we reduced it to writing. The employer sent it on company letterhead, asked the employee to countersign. And that's sort of how it works. The EEOC will be looking for documentation relative to this. Please have something. Well, we did it by text message. I guess that's okay. Make sure the text messages are saved. We did it through verbal, email, and text messages. Emails should be saved, text messages should be saved, the verbal should be reduced to writing. They're going to want to see the process that you went through, and do not try to force something down the employee's throat that wasn't arrived at during these discussions. To request an accommodation, some of you have nice forms and nice policies. The employee doesn't have to, quote, necessarily follow the policy or submit the form. I need help. I need an accommodation. They don't have to fill out these magical forms. You can fill it out for them. You could ask them to fill it out, and but you can't sort of make them and then take the position, well, you didn't fill our form out, therefore we're not going to consider the request. That's a big no-no. The employee or the employee's representative, and I'll come back to that in a second, need only communicate to the employer that there needs to be an adjustment or change at work due to some limitation. The employee's representative, let's say it's a union, the employee's a union member, the union comes forth. Let's say it is the employee's doctor that writes a lengthy letter, and we have to engage both the employee and the doctor in the process. The request does not have to identify the medical condition or use medical terms. I think to a certain extent, the less you know, the better. And you keep the circle small. Supervisors only with a need to know should be in on whatever the accommodations are being discussed are. Obviously, there has to be some disclosure, but you don't have to go crazy and get a 4-page written opinion from the treating physician. To determine the appropriate reasonable accommodation, you must engage in the informal interactive process. It is nothing more, folks, than a discussion with the employee. Keep it that way, and just make sure you keep it informal. This is taken directly from the ADA and the human rights law. This should not be new to you. The ADA and human rights law have required for decades that you as employers have chats with employees when they need a reasonable accommodation, that you proceed in baby steps relative to the accommodation process. You start with the employee. Let's have a chat with the employee. Let's go through the information. Do we need to expedite it and go further? It depends. I think the simpler you keep it, the better off it is. I think I've generally described the interactive process, but the second and third bullet point here are very important. Simple and straightforward, and no rigid steps. If you have a rigid policy, you must be flexible with it. They don't have to necessarily follow the policy. They don't have to complete the form. You can complete the form for them. Maybe they sent you an email. Well, you take the form, see email, attach it to it. Be flexible in your approach to the entire interactive process, and documentation is absolutely critical. You document, you're in great shape. If you don't, and there's a claim filed because the employee claims that the process broke down or maybe didn't occur, where's your proof? The EEOC is definitely going to want to see it. Limitations on supporting documentation. You as an employer can only request documentation when it is reasonable under the circumstances. And in some situations, it's not going to be reasonable. Self-confirmation, a simple statement from the employee where the employee simply confirms that I have a covered condition and the change or adjustment is needed due to the condition. So I need to put my feet up from time to time. Can I have a $25 footstool to put under my desk so when I'm working, my feet are elevated? And the employee presents to you as 6 months pregnant. What documentation are we going to request? A note from the provider saying, is this reasonable, or are you simply going to accept it? I think it's self-confirmation. You simply are going to accept it relative to the condition. It is obvious. And if you get into a request for medical records or asking questions of healthcare providers, you must proceed in baby steps and only ask what is necessary. So one case I had litigated once, the employer said, we want all your medical records. Here's a medical release, which was open-ended, and they could gotten anything. And by the time it got to me, I'm like, what is this piece of paper, and why did you give it to the employee? It was too late. The employee had signed it, and they were off to the races getting medical records that they had no business getting. The medical release must be tailored specifically to the accommodation request. It can't be all medical records. I don't care about all medical records. I only want enough information for me to try to assess, is the accommodation request reasonable under the circumstances? Nothing more. All right, nothing more. And usually we start with the employee. Second, if the employee, not quite what we expected, I do a letter to the healthcare provider. I give it to the employee and I give them a deadline. Hey, could you get us this by this date and just answer these 4 or 5 questions? Um, and we hold our breath. Hopefully it comes back. Let's assume it does. We're done. Or let's assume it comes back. The EEOC gives some nice examples in the regs of bad medical notes. Um, an employee has a pregnancy-related condition, and it comes back signed Dr. Jones, chiropractor. And you're like, what? That can't be right. Well, maybe it is. And maybe the employee has a back condition caused by the pregnancy, and there's something that they're asking for, maybe a different type of chair. You may have to consider it. You're okay to be suspicious of medical notes, but there may be a reason for it. Pregnancy-related case. All of a sudden, it comes back from a cardiologist. Maybe there is a heart condition because of the pregnancy. So be flexible and proceed in baby steps. Only ask for what you need to make the assessment. And I think that way you're playing it safe right across the board. Not unreasonable under the circumstances. The limitation and adjustment needed are obvious, and the employee provides self-confirmation. That's that footstool example that I gave you. The employer has sufficient information to determine whether the employee has a limitation and needs an adjustment. Well, I take a look at the female. The female is 6 months pregnant, and she is showing. Okay, is that enough information? I think it is. Or maybe it's early in the pregnancy and the employee hands them a note from their provider explaining the situation, and this is what we need. Okay, you probably have enough information. Predictable assessments, Ari went over these. I think it's nothing more than the application of common sense. Quote, allowing the employee to go to the restroom more, to have water at her desk. Not a big deal, and I'm not even aware of any of my employers having rules forbidding how many times you can go to the restroom or having water at your desk. I think those predictable assessments are simply common sense, and that 99.9% of employers probably already follow them. The accommodation is related to a time and or place to pump or nurse at work, and the employee provides self-confirmation. I need to do this, and you allow them to do it. You will know if the employee had given birth. You will have already complied with the New York State Nursing Mothers provision. The employee you would have asked, and the employee should have told you by now whether there will be a need to pump, and then you'll have the arrangements made in the appropriate room or area to do that in. I'm not sure what else you need relative to that, and it should be nothing more, to be frank. When the accommodation is available to other employees under the employer's policies. An example, you have a bad back and you can request You got these nice comfy chairs, but you need to request them from HR if you have a back condition or something. You can do the same if you're a pregnant female, and it's simply just ask. If there already is a policy in place, it has to apply equally to females under these regulations. When What is reasonable documentation? When reasonable under the circumstances, an employer may seek minimum documentation. This is the baby steps. I asked if sometimes employees are wishy-washy or maybe can't explain things, and you do have a question for a healthcare provider, make the request. I put the request in writing. I give it, it's a letter. I address it to the provider. I hand it to the employee. Please go ask your provider to give us this answer. Sometimes we have to expedite that. Usually it comes back in a letter or a note, and that should be the end of it. But sometimes the physicians are not clear, and we ask the employee to sign a medical release, maybe allowing us to speak to the physician solely to get clarification of what this note is. Okay, I think that's going to be okay. But I think it's minimum documentation, baby steps, assess it. What do you really need? And don't go overboard. A lot of this is simply going to be your discussion with the employee relative to the condition and coming to some, negotiated, if you would, understanding. You can request documentation from a healthcare provider, including the list that is up here. I think it sort of depends on the issue that the employee is presenting to you, what the accommodation is, maybe some disclosure from the employee who she is seeing for this issue. Please remember, it is not just physical. The list here, you got psychiatrists, mental health professionals, psychologists. Just keep all those things in mind. This can come at you in a lot of different ways. You as an employer cannot require that the provider submit documentation, being the provider treating for the condition or issue. Many employees have multiple healthcare providers. It could be a specialist. It could be their OBGYN. It could be their PCP. I don't know how the employee is choosing to seek out and get their medical attention. And you get a note from the PCP. Well, wait a minute. I wanted this from the OBGYN. Well, stop. If it answers your questions, that's all that matters. And you can't require, you must go give me this from employee or a healthcare provider X or healthcare provider Y. You cannot require that things be submitted on a separate form. You can ask, but they don't have to do it. And if they give you an email or a letter or whatever the case may be, just attach it to your form and say, see attached. That's sufficient. Don't make it such a formal, overbearing process that the employee is having a hard time doing it, following your rules, completing the forms. The key is make it simple, folks. Undue hardship. We, as employment attorneys, get this question a lot, both under the ADA, the human rights law, now these regulations. Undue hardship, in essence, means significant difficulty or expense. There are many factors that you're going to have to consider. The difficulty aspect. Well, I got to rearrange one thing. Well, that's not difficult. That's simple. The expense. How about that footstool? $25. A lot of time, some other things, a screen, some type of screen monitor that covers up to help with eyesight. Okay. If it's a simple thing, do it. Don't make a big deal about it. I had an employer once call me, I kid you not, it's nothing to do with pregnancy. The individual had an eye issue and they wanted the fluorescent light bulbs above their desk reduced from 4 to 1 so that they could much more easily see the screen with their eye issue. And I got the call, and I'm like, all you had to do was unscrew those 3 light bulbs. The employee is correct. Don't make a big deal about it. Simple, no expense associated with it. You need to consider the nature and net cost of the accommodation, the overall financial resources of the facility, the number of employees at the facility, and the effect on expenses. I need that $25 lumbar support. Probably reasonable. Versus, you ever see one of those fancy massage chairs that cost like $5,000? Oh, well, I need that. Well, I think one will be denied and the other is probably going to be granted. So if you deny something based on undue hardship and there is a charge that is filed against you, they're going to start inquiring, what are your overall financial resources at this facility? How many employees are at the facility? How did this affect your bottom line if you were to have granted it? You're going to need to answer some hard questions. And this is not if your defense is solely undue hardship, this is not somewhere we want to be. It is the undue hardship defense is the last line of defense, pure and simple. We want to, I try not to rely on undue hardship. I think the negotiation with the employee is the way to go. Overall finances of the employer, the operations of the employer, the impact on the employer's operations if the accommodation is granted, including the impact on the ability of other employees to perform their job duties, and the facility's ability to conduct business. If the accommodation impacts 10 other employees and allows the one employee to do their job, but does not allow the other 10 employees to do their job, or causes the facility to have to close its doors, it's not reasonable, and ultimately the undue hardship request will be sufficient. We get a lot of questions. The accommodation is a temporary suspension of an essential job function. You must also consider the following. So the employee says, I have condition X. I need for the next 3 months the following job function, basically removed, suspended, transferred to someone else. The length of time the employee will be unable to do this job function, whether there is work for the employee to accomplish. If we take this away, what do they do? Is there anything for them to do? The nature of the essential function, including its frequency, and the EEOC will make inquiries about this. And so you really need good records, not just for this employee, but for all your past accommodation requests and how you handle them. Whether the employee has provided other employees in similar positions who were unable to do the essential functions of their position with a temporary suspension of essential functions. If they're, and I think Ari used the example, maybe the employee is the only one that can do this job. So what would that be an example of? Well, maybe the company has a general counsel, an in-house attorney, and that is the only attorney in-house. That seems to be something where this could come into play. So again, it's can we basically, I look at it as, can we take it away? Can we give it to someone else? Does this employee still have work to do? What can we do to try to make the employee's life easy? Why we can continue to operate? I think that's a nice approach to it. I've already put this in that last answer. Are there others who can do the work? that or third parties who can be hired to do the work. Those are also considerations. Whether the essential function can remain unperformed and for how long. I don't know. You tell me. A lot of times, the job description, while an important document, is not necessarily conclusive as to what the essential functions are. It's a piece of the evidence that the EEOC would look at. Two other types of people I like to talk to: the manager that oversees the person, and maybe anyone else in the same position, to ask these questions about what are the essential job functions, and if we're going to temporarily suspend one and there's no one else to do it, how long can that actually stay there to be done? It could be months, Mike. Okay, great. Maybe that's the answer to her question. Or maybe the answer is no, it must be done every week because it is required by law. Then we have to continue to do it every week because it's required by law. Posting requirements: the EEOC has updated its Know Your Rights poster to include information on this law and regulations. Please stay up to date on your employment posters. Just a general warning. I am now practicing 30 some odd years. I have yet to have anyone pass an employment poster test. And what that means is you must have everything up that is current and applicable to you. You can't have anything up that is expired, and usually where we catch you is your workers' comp, short-term disability, or PFL poster, which has expiration dates on it. And then you can't have anything up that misleads your employees, meaning I'm not FEMLA covered, but I decided to put a FEMLA poster up. I'd fail you for that. Why is there a FEMLA poster up? Well, I bought that fancy all-in-one poster, Mike. Well, cover up the FEMLA one if it doesn't apply, because you're misleading your employees into thinking they're FEMLA covered. And next thing you know, that could create problems for you. So make sure your employment posters are up to date. I realize it may seem like you have to have a 30 by 50-foot wall now with all the employment posters that are out there, and the electronic requirement that New York has imposed. But this is a very important compliance piece. I take the position, please put the posters behind glass under lock and key. I had a situation once where we knew the Department of Labor was coming in. We didn't know if it was a complaint or a random audit. I get there early. We go through, I said, where are your employment posters? They show me the posters. Everything is good. What wasn't good, we printed out and put up. They were all taped to the wall. Hour or two later, whenever the investigator gets there, eventually it comes up, can I see the employment posters? And I said, sure, I've already looked at them. Everything's good. We're kibitzing, we're walking out back. And when we get back to where the employment posters were, all we see is the corners of each document where the tape was. Someone came along and ripped down every single one, but the investigator could see it. I just laughed. I said, and I looked at the investigator and I said, well, I guess we know now if this is a complaint by an employee. The employee obviously saw us looking at the posters, updating them, and thought it was important, and he decided to take them all down. That is a risk you run. So make sure your employment posters are up to date. Very important. The remedies, i.e., what the plaintiff can get from you. If there's a claim filed against you, these generally mirror what are found in Title VII of the Civil Rights Act. Injunctive relief is an order of the court for you not to violate the law. Compensatory damages or damages for mental anguish and emotional distress. I was sick to my stomach. I couldn't sleep at night. I had to see a psychiatrist as a result of the actions of my employer. Punitive damages are damages to punish an employer for wrongdoing, to punish you. So if you callously disregard everything that Ari and myself have talked to you here about today, you are in punitive damage world where they can assess monetary damages against you solely to punish you. That's all right. I got insurance coverage. Read the fine print. Punitive damages will not be covered. And most employers don't realize that. You have these employment practice liability insurance policies, great policy to have, but they cannot, by law, cover punitive damages. So you're on your own there. Attorney's fees, if you were prosecuted by a private attorney, they're going to seek to have their fees paid by you if they're successful. Don't be surprised if the legal fee request sometime is more than the damages awarded the plaintiff. That is to be anticipated in this area. So just again, we don't want to get to litigation. If you get to litigation or an administrative claim, you've already lost because you're spending a lot of time with us and we're sending you a bill every month, and that bill is coming off the bottom line. So spend your time, money, and energy up front. Let's do this right. Maybe there is a dispute. Yeah, maybe we're going to give the employee the benefit of the doubt. That's how I like to handle them. Once you get into litigation, you've already lost because it's coming off your bottom line. It's a time sucker from you, and it's going to stress some of your people out. Some important takeaways. You got to train. I am a full believer in training supervisors. One of my clients this year, they created a 3-day over the summer boot camp. They did it one day, a Friday, and then a Friday, and then a Friday. They did all sorts of things. I did 3 of the sessions, one each week on a different legal topic. Your supervisors need to know what they can do, what they can't do, how to handle an accommodation request, especially pregnancy related. Some of your supervisors may say silly things. They need to know what they can and cannot say. Please remember, and this is very important, especially for the supervisors, the employees don't need to use specific words to request an accommodation. It is simply that they give you enough information that you consider it such. And is that fair? Maybe not, but I think you know the words. I need help. I need this. Whatever. They don't have to say, I need a reasonable accommodation under the ADA. They don't have to use those magic words. Take a common sense, practical approach to the interactive process. Talk to the employee. Don't just email and text. Talk to them. Bring them in if necessary. Make it a low-key thing. Bring people in only with a need to know. We want to keep the circle tight on this. There may be limits if the employee is a minor. Just keep that in mind. We may have to bring in parents or guardian. Review the undue hardship factors. If you are going to go down that path, it is your last line of defense. Make sure it is correct, because if you're wrong, there's nowhere left for you to go. It is at the very bottom. So with that, I'm going to wrap it up. Turn it back over to you all to see if you have any questions. If you think of any questions afterwards, or if you're watching this on video, a month from now or whatever, feel free to email us. We'll try to answer general questions. The question we won't be able to answer is when you give me a 20-page hypothetical. It's not a hypothetical, that's a real world situation. But if you talk generally to us, we'll be happy to answer. So I don't know if there are any questions. I do not, I don't see any. Ari, do you see
Uh,
any?
Michael, this is Amy. I submitted a question, but I'm not so sure. It looked like it went to a chat AI, which was maybe not how intended.
Sure, go
Um,
ahead.
but you referenced the posters quite a bit, and do you have a good checklist of ones in New York State that we're required to have?
I don't have it printed out, but if you go to the New York State Department of Labor's website, they have a federal and state checklist
Okay, super.
of employment posters. So normally what I just type in and it takes me right to the web page, New York State Department of Labor employment posters. And usually it takes me, it's one of the first, it's on the first page somewhere. If I recall correctly, it gives you a little link to download it, and maybe a little explanation of what it is. There's a lot of them. I warn you, New York has put up like the 7 or 8 other languages that they typically use. You just got to make sure you find the right one.
Okay, super. Thank you
And
for that.
I think the other way to do it is the EEOC, the U.S. Department of Labor, OSHA. They all have on their various websites their posters for you to easily download, print out, and what have you. And they do change. The New York, I warn everyone, the New York State Department of Labor ones, they typically change every year. When the minimum
Mhm.
wage goes up on 1/1 or 12/31, depending on the year, they roll out a new employment poster,
Okay,
and many employers miss that.
awesome. Thank you for that.
Okay, I see nothing else. Ari, anything else you want to say?
I don't think so.
Okay. Well, we thank you all, and we'll be doing another one of these soon.
Thank you, Michael. Thank you, Ari. That was wonderful.
All
Thank
right, take
you,
care,
Amy.
everyone.
Bye.